Good morning and welcome to a session of oral arguments before the 5th District Court of Appeal. We have 2 criminal cases and 2 civil cases on our docket this morning. Sadie Baker case has been rescheduled. The panel this morning is Judge Lawson on my right, Judge Evander on my left. And the first case is Jeffrey Hall versus the State of Florida. Counsel ready to proceed? Do you wish to reserve any time, sir?
I would ask to reserve 5 minutes, please.
You got it.
Thank you. Alan Diamond on behalf of Mr. Hall.
Sorry, what was your name?
Alan Diamond. Yes. James Madison and Thomas Jefferson, I think, are turning in their graves when they see what has happened in the last 230 years regarding the Constitution. When it comes to the point where police officers can trespass on your land, walk through your backyard, and then use that to glean probable cause in order to obtain a search warrant. And that's what we have in Mr. Hall's case.
Is that an argument for an en banc reconsideration of Wilson versus State, or do you believe that you can somehow distinguish that case?
Whatever will get me my appellant to win, Your Honor, but I do believe I can distinguish Wilson. I know the court just recently ruled on Wilson, and the facts are not dissimilar, and they do both, I guess, look at the Supreme Court's rulings in Oliver and Dunn and the progeny thereof in reaching their conclusions. But Mr. Hall's case is distinguishable from Ms. Wilson's case for a couple of reasons. And I think the Dunn factors, which this court used in Wilson, are appropriately considered in determining, well, Dunn talks about curtilage. But really, curtilage, if you look at it, is more of the legal conclusion of reasonable expectation of privacy. And what the Supreme Court, and the courts underneath it have said that reasonable expectation of privacy is expected in curtilage, and once you get outside the curtilage of a home, that expectation kind of dissipates, and no reasonable person would expect to have privacy in an open field and those kinds of things. And the Dunn factors are...
Counsel, what about the argument, if you're growing marijuana on your property, why should you have a reasonable expectation of privacy?
Well, that kind of begs the question of, you're not going to know someone's breaking the law until you violate their Fourth Amendment rights or other constitutional rights to go find out. The Constitution isn't designed to protect law-abiding citizens of the United States. It's designed to protect citizens of the United States. And if it was, you can fix the ends justify the means.
Is it designed to protect law-breaking citizens?
Yes, thank God.
Okay.
We only law-breaking citizens really deal with the Fourth, Fifth, and Sixth Amendments on a regular basis, and are only in front of you because they've either been charged with the crime or not. You know, if you went with, you have nothing to hide, therefore let's let government just come in your house and look around it whenever they want to, then...
Under the Dunn factors, how is it that Mr. Hall had a reasonable expectation of privacy in the woods that surrounded the cleared area of his property on which the structure is set? Because, I mean, as I understand the facts, the law enforcement officers went first on the east side of the property, through unfenced state-owned property, and on to his property, Mr. Hall's property, and with an unmarked border. They just, walked through the woods to the property and then viewed what they viewed from the edge of the wooded area. So I'm having a hard time understanding.
Well, and I don't know if he had, I know the diagrams are made part of the record. I don't know if you had a chance to review that. But if you'll look at the record, it's clear, and even Judge Morgan, who was the finder of fact in this case, determined of the 13-acre parcel of land which Mr. Hall had and owned and is the subject of this issue, the police testified that they crawled through very, very, very thick brush and undergrowth, which was private or public lands in part, also trespassed on non-party property as well. But then when they got to Mr. Hall's property line, which they had a pretty good idea where it was, clearly they knew they were on his land, and the deputy testified to that at the hearing. They then proceeded to continue to crawl hundreds of yards through the brush until they got within 30 feet of the house.
I mean, just having grown up in North Florida, which is
Right.
more rural than it is now. I mean, if you're walking through woods and there's no demarcation as to where one property owner's land ends and another begins, how does anybody have a reasonable expectation of privacy in that wooded area? We can just cross into it without crossing a fence or even knowing that you're on another person's property in general. I mean, we're talking about an objective standard, not that the police officers knew where his property line was because they'd researched it, they'd done the flyover. But, I mean, anybody walking through the woods would just keep on walking, I would take it, and wouldn't know where Mr. Hall's property started. He hadn't marked it from that side.
But I think once you get within 30 feet of the house in that clearing, then you would assume then that is that property owner's property, and as you start approaching it.
That's certainly not what we found in the Wilson case.
No, it actually, in the Wilson case, you said 100 feet was close enough to be considered curtilage, and we're talking 30 feet in Mr. Hall's case, and that is one of the distinctions, because the first factor done is the proximity to the residence, the mobile home in this particular case. Both the mobile home and the barn in Mr. Hall's case are within 100 feet of where the police officers were and within 100 feet of each other.
Let me ask you, you keep referring to the residence. This was a building that was not used as a residence. Does that hurt your case?
The evidence in this case is that he had running water, had electricity, had a couch, had a refrigerator, had a sink, had a toilet. It was deemed to be a mobile home, had a front porch light. They were checking for vehicular traffic.
And found, I mean,
When they looked
as I
at
remember,
them,
they did the flyovers and determined that it was an unoccupied structure, or that they were unoccupied structures.
I am saying if they did one flyover, and at the single time they went over, there was not a car parked there. That's not, I don't think that is determinative of whether a mobile home is a residence or not. And that's, I think, part of the state's problem in this case is that the police did absolutely nothing other than flying over one time to determine whether this mobile home in a rural but residential area, it's a bunch of 10-acre, 12-acre, 15-acre tracts of land together off of Broadstream Road, was or was not a residence. They knew there was a mobile home there. They knew it had electricity. They knew it had water. They knew it had, once they went in, they determined it had a sink and a couch and toilets and those types of things. And in the affidavit and the warrant, it's consistently referred to as a mobile home, a mobile house, a mobile home, with a barn within 100 feet of 90 feet of it.
So is this sole distinction you're making that the cleared area, so the demarcation between the woods and the structures were closer in this case than they were in Wilson, and that means that when they got to the edge of the clearing, the edge of the woods, that they were now in the curtilage, and that's the distinction you're making? That's the argument?
That's one of the distinctions. I think all four of the factors underdone, we can draw a distinction. The proximity in Mr. Hall's case is significantly less, 30 feet versus hundreds of feet in Wilson. As in Dunn, they talk about enclosures. What we have is a artificial and natural boundary protecting the Hall house and barn and that small enclave of grass in the middle of the larger area, which is also gated at the front entrance. There are locked gates guarding the driveways.
Yeah, would you agree, though, that that factor was stronger for the defendant in Wilson than here because there was no trespassing signs, there was fencing on all four sides rather than if there were two or three sides here?
Well, I think the demarcation of the outer property barriers in Wilson and in Dunn and Oliver are clearer from, I guess, a non-educated person's perspective in that, not familiar with the property. But you're also talking significantly larger tracts of land. Dunn, we're talking hundreds of acres. Oliver, we're talking 300 or more acres.
Well, with Dunn, you had fence within fence within fence.
And they said that was...
And Wilson, you had fence all around and no trespassing signs. Here, from, I believe, the east side, there was no fence and there were no trespassing signs. At least as to that factor, would you agree that the defendant in Wilson was in a better position than your client in this case, as to one of those four factors?
If you presume that knowledge or lack of knowledge on part of law enforcement is not a factor, then yes, Wilson is in a better position. But since the officers clearly knew what they were doing at the time they were doing it was illegal trespassing, they were clearly going onto Mr. Hall's property. They climbed a fence on the west side. And
But that's true in all those cases. They were trespassing. I mean,
and it still shocks my conscience. And so I want to bring it up. It boggles my mind that the police can break the law in order to get probable cause to then go try to get a warrant.
I mean, it may well be that the U.S. Supreme Court decision surprised you and surprised some of us, but it's the U.S. Supreme Court decision.
I understand that, but I think when you're looking into really Oliver and then Dunn, which kind of sets out the factors that you need to look at in order to make this decision. Yes, sir. The four factors, the use of the area, the enclosure, the fact that it was not cordoned off.
But is the use of the area also stronger for the defendant in Wilson than your client, since he had a residence there and other buildings, and your client was not using the mobile home as a residence? Is that factor also stronger for the defendant in Wilson? Now, you have the distance factor as a plus for you versus Wilson, but it seems to me these other factors may be stronger the other way.
From the record that you have before you, the residence factor is not clear, as clearly defined as it was in Wilson, but there are factors there I think will make it as strong as Wilson, in that there is no indication other than it was or had been recently used as a residence, in that it had utilities, it had couches, it had refrigerators, it had running water, indicia of residence, and that none of that was determined until after law enforcement went into the home. They did nothing in order to, I guess, refute the fact that it wasn't, in fact, a home, and until they know that it's not being used as a home, I think the Fourth Amendment...
But, I mean, it seems like you're attacking this from the angle of what law enforcement subjectively knew, and the real question is whether the owner of the property has a reasonable expectation of privacy. And so whether the facts that indicate that the structure was not used as a residence were learned before or after, I don't see how it matters when they were learned, as long as they teach us something or show us something about whether Mr. Hall had a reasonable expectation of privacy. And if he wasn't using the trailer as a residence, then that's a relevant factor, and it doesn't matter when or who knew that when, as long as we can tell that now. I mean, from a constitutional standpoint, as far as I can tell.
I'm not conceding that it wasn't being used as a residence, and what I'm offering is that the record would support the contention that it was being used as a residence, and that it was a home, a mobile home. It had utilities, it had places to sleep, places to sit, refrigerator for use for eating, things that one would associate with a residence that can be resided in. And there is nothing to refute that conclusion in the record before this court. That in fact, it was a residence. It was a mobile home, and that people were residing in it and using it as such, that it wasn't just a giant grow house.
I thought I remembered the record differently, but I'll have to look back.
I just want to save a few minutes for rebuttal. So, thank you.
Ms. Donnelly?
Good morning, Mary Jolly on behalf of the state of Florida. Initially, I just want to refute that argument regarding the residence. Again, this is an appeal from the denial of a motion to suppress. This court is mindful of the court's standard review, and the trial court made findings that there was no evidence of anyone residing in the home or staying at the mobile home, and no evidence of any business activity being conducted. That's factual finding number 7 in the order. And I don't think Mr. Hall has come forward with any evidence to say that that finding, to refute that finding. And I think that that finding is integral to this court's conclusion that the ruling denying the motion to suppress must be affirmed, because there is no expectation of privacy. And when I started thinking about this, there's no residence that demonstrates the sort of intimacy of daily life. And that's what is at the root of these issues in terms of the Fourth Amendment interest. And if there's no residence, there's essentially can't be any curtilage, and there's no legitimate business here. There's no legitimate purpose. This is a property used to grow a lot of marijuana. And I think that it's fundamental, the root of his problem, the root of the argument that fails here is there's no expectation of privacy, because it simply can't be a plot of curtilage, because there's nothing there that can attach to, because
So
there's no...
you're saying that if there was no residence, if it wasn't in use as a residence, that if the clearing was 3 feet from the mobile home, it'd still be okay?
Yeah, there's no intimacy of privacy, or alternatively, because I was looking at some curtilage cases in a business context. If it was a legitimate business operating, there's case law out there in a different context in terms of burglary, but examines curtilage in that context, and it's neither here. And I think when we go through, and that coupled with the fact that contrary, and I think our facts are even stronger than Wilson in terms of the fact that there's no perimeter fence here. There's a small fencing on the western boundary. No one lived there. These factors in the state's position make this case even stronger for an open fields finding than in Wilson. And again, what the officers did here is then they went and procured a warrant, and it's that standard of review that this court is bound by in terms of looking at the four corners of the affidavit and whether there was competent substantial evidence of a finding of probable cause. And this court, after the trial court has reviewed the findings of the magistrate and signing the warrant, this court reviews that, and it's our position that comes before this court with a presumption of correctness of the record overwhelmingly supports the finding of probable cause. And under Wilson, this court, and unless this court wants to sit en banc and recede from a case from 4 months ago, this court should follow Wilson and affirm this finding in all respects. It's a good open fields case, and they've come forward with nothing to demonstrate that Wilson was legally incorrect, and the facts are stronger than in Wilson. And unless the court has any other questions, we'd ask that you affirm in all respects. Thank you.
Give about 3 minutes.
Just in conclusion, Your Honors, I would ask that, as the court is aware, under the Dunn factors, it's a case-by-case analysis, and I would ask that you look at the proximity of law enforcement and the areas that they got to before they were able to determine probable cause to support their warrant, which is less than 30 feet. That the area was enclosed in a single enclave by natural and artificial boundaries, that there is record evidence to support that it was used as a residence. It's a mobile home. They believed it was a residence, or could have believed it was a residence, should have believed it was a residence, and that the final factor that when you look at it is the steps that the property owner, homeowner, took to ensure his privacy in between the natural boundaries, which the testimony was it took.
Counsel, you refer to this as a homeowner. Is there any evidence at all that this was being utilized as a home?
None other than what I've stated, other than it had utilities, it had a place to sleep, it had a place to prepare and keep food. You know, I don't know how else to describe a home.
Well, a home is where somebody lives, and there's no evidence that anybody was living in it. You can have a house with all those things you've mentioned, and nobody lives in it, so it's not a home.
Then, by that same analysis, 50 out of 52 weeks of a vacation home, you have no expectation of privacy in it. You know, you can't be at home all the time, and if this court is saying that you have to be home all the time in order to consider it a home and have an expectation of privacy, then...
Well, not all the time, but certainly it ought to be a place you consider your home, a residence, or even a vacation home, for that matter.
But hotel rooms count, and you're only there for a brief period of time. Your car, you have an expectation of privacy in. You don't live in your car all the time. You know, the case law and Dunn, I think, in all those cases really go down to, forget curtilage, forget those types of arguments. It comes down to reasonable expectation of privacy. And when you have a home, a building that you own that's protected by gates, by fences, and by impenetrable underbrush, that you have an expectation of privacy. You don't expect anyone, much less law enforcement, to be trespassing on it. And that's what Mr. Hall had, and I would ask that this court find that, in fact, his constitutional rights were, in fact, violated.
Thank you.